All right, we've got some news now regarding the oral arguments that were heard by the U.S. Supreme Court earlier this week from the Trump administration regarding the executive orders and how federal judges have been injuncting them, and the use of the Alien Enemies Act, and the argument over birthright citizenship. Well, we've gotten a ruling, unfortunately, on one of them today, but we're going to lead into where, well, our biggest problem currently sits up on the bench of the highest judiciary in the land. Amy Coney Barrett, earlier this week, grilling one of the attorneys from the Trump team over the fight to push back on radical activist judges and their unconstitutional injunctions. Listen to this.
Opinions and judgments here. Did I understand you correctly to tell Justice Kagan that the government wanted to reserve its right to maybe not follow a Second Circuit precedent, say, in New York, because you might disagree with the opinion?
Our general practice is to respect those precedents, but there are circumstances when it is not a categorical practice. It is, and that is not
this administration's practice or the longstanding practice of the federal government. And I'm not talking about in the Fourth Circuit, are you going to respect a Second Circuit? I'm talking about within the Second Circuit. And can you say, is that this administration's practice or a longstanding one?
As I understand it, longstanding policy of the Department of Justice. Yes, that we generally, as it was phrased to me, generally respect circuit precedent, but not necessarily in every case. And some examples might be a situation where we're litigating to try and get that circuit precedent overruled and so forth.
Well, okay, so I'm not talking about a situation in which, you know, the Second Circuit has a case from 1955 and you think it's time for it to be challenged. That's not what I'm talking about. I'm talking about in this kind of situation. I'm talking about this week, the Second Circuit holds that the executive order is unconstitutional, and then what do you do the next day or the next week?
Generally, we follow those.
So you're still saying generally?
Yes.
And you still think that it's generally the policy, long-standing policy of the federal government to take that approach?
That is my understanding.
Okay, so, but it sounds to me like you accept a Cooper versus Aaron kind of situation for the Supreme Court, but not for, say, the Second Circuit. Like where you would respect the opinions and the judgments of the Supreme Court, and you're saying you would respect the judgment, but not necessarily the opinion of a lower court.
And again, I think in the vast majority of instances, our practice has been to respect the opinion as well, in the circuits as well, but my understanding is that has not been a categorical practice in the way respect for the precedents and the judgments of the Supreme Court has been.
So you're not hedging at all with respect to the precedent of this court?
That is correct. I believe the quotation from our application directly addresses that, and we stand by that completely.